My lord, item number 40, item 44 of the 2 days list, my lord. Lordship may remember this is a wagon matter, this central excise matter. It was quite part hard, but it is not mentioned as a part hard. If your lordship kindly take up any date as per your lordship convenience, because
Right. We'll make a note. Next week we will upgrade it.
grateful, my lord.
Lordship, may I have your lordship's leave to file an appeal without certified copy? Your lordship, the order is dated 19th of August, passed by the learned single bench sitting in the circuit bench of Jalpaiguri. Which said,
Circuit is going to start from first.
Lordship, I'm aware it's starting from first, but your lordship, if your lordship kindly
What
grants
is the urgency?
Lordship, my goods are stuck with the GST authority.
Goods are stuck for how long? 45 days, 75 days?
No, Lordship, it's there
Please
from.
see, the problem is once leave is granted, there are a lot of issues in sending back the recording, and your client will put to further delay.
Very well, Lord.
Please.
My lord, this is a contempt. Your lordship was hard and honorable justice beyond my watch.
Yes, next week we are going to sit.
My lordship, kindly to mention item number 48, my lord. Now, it is a new admission matter, my lord. My lord, the tribunal fixed the matter 3rd September, my lord, for implementation of the order regarding payment of interest, my lord. We have challenged here the issue of on the point of jurisdiction of the tribunal as well as the rate of interest, my lord. If your lordship kindly take any date, my lord, on next.
Now what we'll do is tomorrow we'll put it under the caption to be mentioned.
Grateful, my lord.
So that the respondent will appear.
My lord,
I'm appearing for the respondent. My humble praise, can it be taken out on Monday or Tuesday?
But then the problem is at the same time you shouldn't throttle them before the tribunal.
My lord, just 1 day accommodation I am seeking. Tomorrow I have different.
They say that the order has to be implemented by 3rd.
My lord.
You please defer that request.
My lord, in that case, let it be taken up tomorrow.
My lord, if your lordship kindly just, if your lordship, we will take only 10 to 15 minutes before, my lord, if your lordship kindly.
You let it come tomorrow. Huh? To be mentioned tomorrow.
Grateful, my lord. Grateful.
Yes, please call.
Original side
May I
daily
have
list.
my lord's kind leave to mention one matter?
Ah.
Your lordship had heard this matter, my lord Manoj Jain. My lord, we were stuck on the last day. It was covered judgment, my lord. Whether the judgment was thereafter appealed against, but we had indicated it's not been appealed
The
against.
number we listed.
I'm very grateful, my lord. Very grateful.
Please call.
Original side daily list. Item number 1. New application tax matters.
Your Lordship, we have
There is-
not been served with a copy of the brief. Mr. Oberoi is appearing on that.
You have been served.
No, Your Lordship.
Delay we will condone 101 days.
I'm great.
You have heard so and so. There is a delay of 101 days in filing the appeal. As the delay has been properly explained, the same is condoned.
There is a delay of 101 days. May
Condoned.
I hand over the copy, my lord?
The copy of the appeal papers have been handed over to the learned advocate for the respondent assessee. List after 2 weeks. By then you get ready.
I'm grateful, my lord.
Yes, Mazmundar.
Item number 2.
Item number 2, my lord, there is a delay of 244 days.
We'll
I'm
continue your
appearing for the
opposing.
respondent, my lord. Lordship?
You want to oppose.
No, my lord, we don't want to. Leave it to your lordship.
Delay condoned, let it come up.
My lord.
Next.
Item number 3.
My lord, item number 3, my lord, there is a delay of 497 days.
What is this? TA?
Yes, madam. My lord, here, my lord, issue is the assessee challenge before the tribunal mostly on the point that the order should not be passed by the DCIT, the order should be passed by the ITO, because there is a CBDT circular that up to 30 lakhs, the ITO should be passed order, not, and thereafter DCIT passed order. That is the main point taken.
Delay will be. You have heard so and so, so and so. The respondent has been served, but none appears for the respondent. There is a delay of 497 days in filing the appeal. The impugned order was passed by the learned tribunal on 16/10/2023. certified copy of which was received by the Income Tax Department on 29/11/2023. The appeal ought to have been filed on or before 27/3/2024, but was filed only on 7/8/2025. And there was a delay of 617 days,
Well, 400.
which after deducting the after deducting 120 days, the time provided for filing the appeal, there is a delay of 497 days delay of 497 days. We have perused the affidavit filed in support of the application for condonation of delay, and we find there is the reasons set out therein do not qualify as sufficient cause for the inordinate delay in filing the appeal. For such reason, the application in GA 1 of 2025 is dismissed. Consequently, the appeal stands rejected. The substantial questions of law suggested are left open.
Deeply.
Next.
Item number 4.
Well, here is delay of 231 days.
My lord, I want to oppose, my lord.
All right.
Well, 4, 5,
6 and
6,
7.
7.
4, 5, 6, 7. There is a delay of so and so days. The learned advocate appearing for the respondents seeks time to file affidavit in opposition. Let such affidavit in opposition be filed within 3 weeks from date. Reply, if any, within a week thereafter. List on so and so. 3, 4, 5, 6 separate orders.
4, 5, 6, 7.
Item number 8.
I'm appearing for the respondent, my lord.
Well, 232 days.
Are you opposing the delay?
No, my lord, I'm not. Just another thing, my lord, the respondent has been served the brief last Friday, which is why they couldn't file the.
We have the matter after 2 weeks. By then you get ready.
Deeply obliged, my lord.
What is the issue, Mr. Soman?
Well, here also, my lord, bright colors. Well, here also, my lord, 68.
Net worth has been proved. They have all responded to the summons.
My lord, just the directors did not appear. That is the ground.
They have appeared in person. They have produced all the information which was called for, along with their written submissions. There is a delay of so and so days in filing the appeal. As they are 232, as the explanation offered is found to be satisfactory, the delay in filing is condoned. The application in GA 1 of 2025 is allowed. This appeal has been filed by the revenue under section 260 capital A of the Income Tax Act 19. Sit down and take. Sit down. Under section 260 capital A of the Income Tax Act 1961, within bracket the Act, challenging the order passed by the Income Tax Appellate Tribunal A Bench Kolkata within bracket Tribunal in ITA number 96/KOL/2024 dated 24/6/2024. The revenue has raised the following substantial questions of law for consideration. Page number 8 and 9 of the stay application, question numbers Roman 1, 2, 3, and 4. We have heard so and so, so and so. The short issue which falls for consideration is whether the learned tribunal was justified in setting aside the order passed by the Commission of Income Tax within bracket appeals within bracket CITA and deleting the addition made under section 68 of the Act. We have perused the reasons, the Reasons assigned by the learned tribunal for allowing the assessee's appeal. It is seen that the assessing officer issued notice under section 133 within bracket 6 of the Act to the investing companies, and both parties had complied with the said notice and furnished the requisite details. Full stop. Summons under section 131 of the Act was issued to the director of the assessee company to be personally present and also to produce the directors of the investing companies for examination of genuineness of the transaction, identity and creditworthiness of the lenders. The tribunal notes that the directors appeared pursuant to the summons, but the assessing officer wrongly recorded that the directors of the assessee company failed to appear in response to the summons issued under section 131 of the Act. Furthermore, the tribunal examined the factual position and noted that the assessee has filed evidences as called for by the assessing officer in respect of the assessee as well as the investing companies. The evidences filed comprised of the income tax returns, audited balance sheet, profit and loss account, audited reports, bank statement, and master data in respect of each of the subscribers. Furthermore, both the parties have submitted their reply pursuant to the notice issued under section 133 within bracket 6 of the Act. After noting these facts, the learned tribunal held that the assessing officer as well as the CITA did not cause any verification or conduct any inquiry into the evidences which were filed by the assessee, and merely harped on the non-compliance of summons under section 131 of the Act, which is factually incorrect. The learned tribunal placed reliance on the decision of the Honorable Supreme Court in CIT versus Orissa Corporation Limited, 1986, 159 ITR 78 within bracket SC. As well as the decision of this court in Crystal Network Private Limited versus CIT, 353 ITR 171 within bracket Calcutta. Full stop. The tribunal also noted that decision of the coordinate bench in the case of ITO versus Cygnus Developers India Private Limited, ITA number 282/KOL/2012, wherein the factual position was also similar to that of the case of the assessee. Thus, we find the facts have been examined by the tribunal and a conclusion has been arrived at, and we find no question of law, much less substantial question of law, arising for consideration in this appeal. Accordingly, appeal fails, dismissed.
My lord, leave to file the wakalatnama. Leave to file the wakalatnama.
Vimal Kumar.
But they file an application for correction of the cost title. This is a St. Lexus. They went 2011 St. Lexus of Commission of St. Lexus. Now it is with CGST or CS. Now, this appeal may be dismissed. Actually, within the passage of time, we have paid.
First we will allow this.
Yes.
We will allow this application.
Not appeal. It will be dismissed for
Application.
Yes. Application would be allowed.
No. GA 2 of 2025. This application has been filed to correct the cost title. Prayer sought for is not opposed by the learned advocate standing counsel appearing for the respondent department. Accordingly, application stands allowed. Necessary correction be carried out in the cost title. Now, where is the appeal?
Appeal is a short point, Lordship. This is the interest we have paid. So therefore, appeal would be dismissed for non. As we
already complied with.
Yes, complied.
You show one of your papers. Appeal paper is not here.
My paper, sir.
You have got the copy of the appeal.
I am also saying, just now I got and I seen that there is a demand of interest 67,000
that has been paid.
Paid. So my prayer is that.
But if one of you can give at least a memorandum copy.
Yes, my lord. During the course of the day, I think I might require 15 minutes time.
No, you can take 2 photocopies.
I'll supply to them
Yes.
during the course of the
Appeal
day.
has been filed challenging the order passed
by the tribunal,
by the Customs, Excise and
Service Tax Appellate Tribunal.
Service Tax Appellate Tribunal, Eastern Zonal Bench, Kolkata, within bracket Tribunal, in Excise Appeal number E/73/2010, dated 25/12/5/2010. We have heard so-and-so learned senior advocate appearing so-and-so. It is submitted by the learned senior advocate appearing for the appellant that the interest which has been directed to be paid has been paid by the assessor. In such circumstances, nothing further survives for adjudication in this appeal, and accordingly, appeal stands disposed of as having become infirmable.
I am grateful.
Next.
Deeply obliged, ma'am.
Item number 10 and 11.
My application for substituting the name of the deceased appellant.
And who has to be substituted?
Executed to the will of
The wife.
executed. The
Executor of the will, unregistered will.
All right. This application, GA 4 of 2025. This application has been filed to substitute the applicant, Srimati Vimala Devi Podar, in the place of the deceased appellant.
Vimala Devi Podar is the deceased.
Oh, sorry. Substitute the name of the applicant.
Harshvardhan Vatia is the sole executor of the will.
Okay. By mentioning the name of Mr. Harshavardhan Neotia, son of late Vinod Kumar Neotia, who is the sole executor to the last will and testament and administrator of the estate of the deceased appellant, Srimati Bimala Devi Podar. The prayer sought for is not opposed by the revenue. Accordingly, the application is allowed and the cost title be accordingly amended. And the name of Sri Harshavardhan Neotia, son of late Vinod Kumar Neotia, is substituted in the place of Srimati Bimala Devi Podar. Same order in the other application?
Yes. Same.
Same order, their GA number will be 2 of 2025. Yes.
And may I find this?
Item number 12. My lord, I oppose the respondent.
My lord, there is a delay of 496 days.
And
My
there
lord,
is no
this issue is by approval by the specified authority, my lord.
Very wrong, sir.
Impugn order is page 82.
These are all, see, even assuming you have a contestable case, the court has not foreclosed you. In fact, they could have gone to that extent. I have passed orders like that, saying that this defect is incurable, entire thing goes, but that they have not done. So in the file noting, what you can do is, though the grounds are there, carrying the matter on appeal will further delay the matter. Therefore, with that reservation, you comply the direction. Commissioner Legal can put up that note. On paper, on record, it should say that you don't accept this view because of XYZ reasons. But you can take a decision to comply because it will avoid the delay.
In fact, my lord, had that notice been issued at that point of time, matter would have ended.
By now, they would have been here. There is a delay of 496 days in preferring the instant intra-court appeal against the order and direction issued in WPO 1064 of 2023, dated 21st June 2023. We have heard Mr. Amit Sharma, learned senior standing counsel for the appellant, and Ms. So-and-so, learned advocate appearing for the respondent assessee. We have carefully perused the averments set out in the affidavit filed in support of the application for continuation of the delay. Except for stating that the file has been moving from one officer to another, there is no acceptable explanation given for the inordinate delay of 496 days. Even assuming the appellant department had sufficient grounds to challenge the impugned order passed in the writ petition, the department can very well take note of the fact that the learned writ court has not foreclosed the department from taking further action, but has set aside the case and remanded it back to the assessing officer to proceed afresh from the stage when the irregularity which has been pointed out by the learned single bench had been committed. Therefore, even assuming the department has certain grounds on which they seek to prefer an appeal, the department can very well decide to comply with the direction issue without prejudice to their contentions, since it would avoid delay in the proceedings. The case on hand is one such classical example where the delay, the inordinate delay, has resulted in the assessment proceedings not being taken to the logical end. Full stop. In the absence of any acceptable explanation and in the absence of sufficient cause being shown for condoning the inordinate delay of 96 days, we are not persuaded to exercise any discretion in favor of the appellant department. Accordingly, the application in GA 1 of 2025 is dismissed. Consequently, the appeal stands rejected. The question of law raised in the appeal is left open.
My lord, one indulgence, my lord. There was direction to comply to cure the irregularity within 8 weeks. My lord, that time.
The time stipulated by the learned single bench to cure the irregularity is extended by a period of 8 weeks from the date of receipt of the server copy.
My lord, I'm ready.
Next.
Item number 13.
This is my application, my lord.
What is your application, Manasi?
So the application is with respect to the rectification only with respect to, my lord, kindly comes to the annexure of that application where the judgment is annexed, my lord. Page 2 of the
rectification of the final paragraph in page 7 of the judgment.
Yes.
Final paragraph in page 7.
Yes.
Therefore, with this reason, the affirmed appeal is partly allowed and the substantial questions of law number 1 and 2 are answered in favor of the revenue.
And substantial questions of law is answered against revenue. My lord, kindly comes to page 2 of Milord's judgment. My lord, has referred to the revenue has raised the following substantial questions of law. Admittedly, my lord, this 1 and 2 is against us, and 3, my lord, is noting is also against us, but partly it is
1 and
in
2.
favor of the SSC and partly against us. Why, my lord? This 1 crore 22 is in their favor, admittedly.
26,101 is.
26 they have already paid, so it is in our favor. So to make an adjustment in the final
So we have to
accepted,
say, in the result, the appeal is partly allowed. Substantial question 1 and 2 answered in favor of the revenue. And substantial question of law number 3, insofar as it relates to the dropping of demand of 122,
No.
is answered in favor of the revenue. And with regard to the remanding 2101 is answered against the assessor.
SSC, which they have already accepted also, the argued also, say recorded also.
No, we should say question 3 is answered in favor of the revenue.
Favor of the, that is what my prayer is.
It's not, my lord. 1 crore 22 lakh was for cargo handling service. Your lordship has given a finding on this. If your lordship kindly comes to page 4 of the order, last paragraph. This leaves us with only one issue, namely cargo handling service. The learned tribunal has taken note of its order passed in respect of site formation service, where the tribunal has affirmed the order passed by the adjudicating authority, dropping the demand in respect of site formation service on the ground that the contract entered by the SSC with third parties was a composite contract and payments were made based upon the quantity of coal which was raised. Your lordship discusses this board circular, and then your lordship comes to page 6. From the above, it is clear that the handling of transportation of coal mines from pithead to specified locations for transportation outside the mine was included. Therefore, it is clear that the activity of handling of goods, including of unloading and loading thereof, being part of the mining services to be rendered under the agreement entered into by SSC, cannot be bifurcated under different heads for the purpose of demanding service tax. Identical issue was considered by High Court of Judicature and all. The court noted and all. Then your lordship comes to next page, page 7. Paragraph 2. In the light of the above, it has to be necessary held that the activity of handling of goods, including loading and unloading thereof, here being part of the composite contract entered into by the SSC with the third parties, cannot be bifurcated under different heads for the purpose of this. And my lord, if your lordship sees the commissioner's order.
Admitted, my lord, admitted.
No, there is no.
No, there is no.
No.
But 26, with respect to 26 crores, my lord, it is not
See, the
excessive.
reasoning is you can't split up both. So therefore, this is correct.
Yes.
This application has been filed for.
Well, whether this can be said that with respect to 26 crore, 1 lakh and 36 is allowed in.
No. This application has been filed by the revenue seeking to modify / rectify the order and judgment dated May 14, 2025 in Sexa 8 of 2025. We have heard Ms. Manasi Mukherjee and a senior standing counsel appearing for the revenue, and Mr. Samir Chaudhary, learned senior advocate, appearing for the respondent. It is submitted by the learned advocate for the applicant department that the last paragraph in paragraph 7 of the page 7 of the judgment has to be modified. We have considered the fact assigned in paragraphs 5 and 6 of the order, and we find that there is no rectification or correction required in the judgment and order. Furthermore, after the judgment is pronounced, the conclusion arrived at or the reasons assigned in the judgment cannot be rectified by way of such application, and the only remedy available to the revenue is to prefer an appeal if they are aggrieved by the order, judgment and order. Application dismissed with the observation. Next.
Item number 14.
In this matter, there is a delay of 706 days.
Similar matter, my lord.
If your lordship will remember, last month, in similar type of matter, your lordship has just given the warning to the department not to repeat this type of matter again. And what they are taking the advantage.
No, now they have rectified it. They have done something. In fact, I came to know. Okay. There is a delay of 706 days in filing the appeal. This intra-court appeal
application.
We have perused the affidavit filed in support of GA 1 of 2025, wherein prayer has been made to condone the delay. To say the least, nothing convincing has been stated for the court to exercise any discretion in favor of the appellate department for condonation of the inordinate delay of 706 days. The stand taken by the department clearly shows that the concerned file was moving from one officer to another, and the appeal which ought to have been filed on or before within 30 days from the date of receipt of the copy of the impugned order was filed after a period of 706 days. In the absence of any acceptable explanation for the inordinate delay, we are not persuaded to exercise any discretion in favor of the appellant department. Accordingly, the application of GA 1 of 2025 is dismissed. Consequently, the
My lord, with that liberty, my lord,
I'm opposing to that, Your Lordship. They are taking the advantage, Your Lordship.
that irregularity has been for 8 weeks compliance.
Not
my
in
lord.
this case.
No.
Next.
I'm much obliged, Your Lordship.
For admission of tax matters, I don't know, 15.
But in this matter, my lord, I am led by learned ASG. This is a Marlin a group of matters, my lord. My lord, the last few days, my lord, he was not well. My lord, cough and cold. Thereafter, my lord, his pressure has been also fluctuating, my lord. That is the position, my lord. We are not able to, my lord, contact with him and sit with him in the matters. But point are, my lord, limited in these appeals. Because, my lord, after, my lord, order passed in the matter of, my lord, Obishare build well. Now, my lord, scope is limited, also I know. But still, my lord, as my lord, learned ASD is appearing, my lord, I cannot take this on my shoulder.
But for the last 3 months, the matter is being adjourned because they want to brief the learned ASG, Your Lordship. This matter was heard by my lords.
That is what we are telling you, Mr. Pratyush. You should also, at least for 1 year, you need to be a standing counsel for the department. Very easy to say from this side. Very difficult to handle. But all right, there are several matters accommodation on the ground of ill health. I am falling sick, they are falling sick. It is submitted by the learned advocate appearing for the appellant department that he is being led by the learned additional solicitor general who is indisposed and not able to attend court, and adjournment is sought for. List the matter. After 2 weeks, you give a date.
And next week, I was approached by the state government to appear. I had given my name to be a part of the panel. My name was rejected.
State government.
And my lord, I was requested by the learned advocate general at that point of time to give my name. I gave my name, but my name was rejected, Your Lordship.
Central government panel will put you in.
We will pursue his name.
1 year you be here this side, you will have a lot of variety. See, because otherwise, you of course, you will have one set of corporate clients, etc. By and large, the pattern of litigation will be the same. In the department, you have a lot of variety. It's like working in a corporate hospital, a doctor, and one working in SSK. So the OP itself is like 300, 400 people every day they will see. On an admission day, it will be more.
I don't know, 22.
2 weeks.
Ready? Because 12 we thought we'll take appellate side. Which one, sir?
Next 23 minute is admission.
23 who left?
I'm appearing, my lord. I'm led by Mr. Dutt. He's on his legs, my lord. Kindly, my lord, fix it on some another day, my
Is
lord.
it covered by any decision?
You know, what has happened is, you know, that of course, there's judgment of our court, you know, with reference to section 50, clause 50C, that, you know, if the assessee disputes, you know, the stamp value, then the assessing officer has to make a reference to the departmental valuation officer. You know, that request was made in course of the assessment. And with the assessing officer held that it is in his discretion. You know, judgment of our court says no, it has to be referred even if the assessee does not ask for it. But that is one part. The other is, you know, that this order was passed 3 months after the hearing. So, you know, the tribunal has completely mixed up the facts. And, you know, the given findings, you know, I had to, the question which is formulated, my lord, will seem, you know, one question, the question number 4, you know, challenging those many findings as perverse, you know, because they're completely contrary to the record. So, you know, they've completely mixed the facts. My lords are pleased to see, you know, in this application note, it is at page 18. But there are 4 documents, not a mere glance at those documents and the findings, they cannot be sustained. They're completely contrary to it. So the valuer had gone to inspect the property. The report records that he had gone to inspect it. They say he did not inspect the property. But they say the valuation is without any basis. The valuation report note mentions land comparison method, comparable sale instances have been cited, discussed.
So factually, the tribunal has
completely deholds the facts of the case. The decision has been taken. Therefore, the question had to be formulated, but specifically to say how wrong they've gone on facts.
That is question number
that Roman 4, Lord.
Roman 4.
Lord, and I have noted the page numbers. Lord, Lord, I can just show in take 10 minutes, Lord, just to have my lords go through those pages and Lord, how wrong the findings are.
Let us see one sample.
My lords.
Roman 4, question 4, 1I.
4I.
4I.
This is not as a matter of law or fact. This is valuation cannot be carried by the valuation officer because construction was proposed to be carried out on the property after demolition of the existing buildings. This is a reason given by the tribunal as to why the assessing officer need not have referred to the valuation officer because the building was proposed to be demolished and construction. But that cannot be a ground to say the valuation cannot be made. But something is there, the building will be demolished, but the valuation can always be made. My valuer went and valued it. He valued the building. There's a separate valuer who valued the building. Another one valued the land. So it can be done, but to say as a matter of fact or law that it cannot be done, that is not completely. Roman 2 is more factual. I cannot show from the record. If my lords are pleased to.
You please show that.
Lordship, kindly take note. The valuation report dated 17 September 2012 of so-and-so was by an overseas valuation agency given without inspecting the property and without any basis. But kindly have volume 3 and formula. I'll point out the relevant pages. But volume 3, page 422.
424.
My lord. . . Look, this is the starting page, look, Cushman and Wakefield. And then look, my lord, so please to have note at page 425. Look, kindly see at the top right-hand side, it's Cushman and Wakefield India Private Limited. It is not an overseas valuation agency, it's an Indian company. And I'll show the credentials, they're part of the record. So it's an Indian company. Then we'll kindly see on that page, paragraph 3, basis of valuation. We understand from our discussion with the client that the basic intention of the exercise is to assess the market value of the property in its current state, its condition on the date of site inspection, hence valuation of the market value for subject properties done on the basis of land sales comparison method and discounted cash flow method. Then the next page, clause 5. We inspected the property externally from ground level on 1st August 2012 by so-and-so. No measurement survey has been carried out by Cushman and Wakefield. We have relied entirely on the site areas provided to us by the client. We have assumed that these are correct. Then sources of information. Information on comparable properties are generally gathered from various sources like government offices, property and revenue department, sub-registrar office, area development authority, municipality office, etc. Reliable sources, public and private auctions, sub-broker of Cushman and Wakefield India, local real estate agents, discussion with local residents, and secondary sources, newspapers, articles, property website. However, for the purpose of this study, the information on comparable properties has been gathered from Cushman and Wakefield India internal team, external brokers, and property websites. Then kindly take note, page 428. There are detailed reasons in support of this, but this is the summary. Market value, unless otherwise requested, the valuation will be prepared in accordance with the definition of appraisal and valuation standards published by RICS, the Red Book, and will be prepared by asset valuers as defined therein. The valuation of the property will be done on the basis of market value as defined in the valuation standard of the Red Book, version so-and-so. The estimated amount for which an asset or liability should exchange on the valuation date between a willing buyer and a willing seller in an arm's length transaction after proper marketing, wherein the parties had each other acted knowledgeably, prudently, and without compulsion. Market value assuming vacant possession. The same note is 1495 million. That's 149.5 crores. There are these details in support of that. If my lords are pleased to see page 432. But the heading is SWOT analysis. The SWOT matrix below for the subject properties aimed at capturing the essence of the general site and location features. Note, SWOT stands for strength, weakness, opportunities, threats. So that is the analysis they have done. Then further details, if my lords are pleased to have volume 4 now. It continues into the next volume.
Now, what has the tribunal done on this?
The tribunal says this is a report by an overseas valuation agency. It is without any basis, no discussion. No, just.
Which is that paragraph of the tribunal?
I will take my lords to that. No, kindly bear with me. No, kindly take note page 445 once more.
445.
No, this is the part D of that same report. No, valuation methodology, commentary, and value. No, I'll just show the headings. Note page 446. One is land sales comparison method. Then kindly see note page 447. Just above the table. The table below provides indicative comparables near the subject property. Then with the subject property, comparable 1, comparable 2, comparable 3, comparable 4. And then they have mentioned the particulars on the left-hand side. The first column, the different features they have noted. Then adjustments which are required to be made, they have done that. Somewhere they've added 15%, somewhere they've deducted 10%. They've properly tabulated here as to why they're making those adjustments. And they discuss the individual items of the adjustments at page 447, bottom going on to page 448. Then at page 449 is the other method, discounted cash flow method. So this is discussed. And then what at page 451, what bottom summary of values following the two methods. And then at page 452. Well, this is where they sum up thing. In an ideal market scenario, the values as derived through land sales comparable approach and discounted cash flows methodology should be in a small range of variation of about 10 to 15%. However, in light to the economic crisis wherein the built-up property prices have corrected, coupled with slowdown in sales and cautious real estate sentiments in the city, it has been observed that the variation in the values through both the methodology tends to be in a range higher than 10 to 15%. It could be one of the reasons also that we are witnessing limited land transactions in the current market, as the landowners have not corrected the land prices in sync with the change in demand scenario. However, as the market improves, we expect the gap between the two methodologies to narrow down to an acceptable range of 10 to 15%. Though our long-term outlook for the real estate market in the city continues to be positive for a land transaction to conclude in the present market, we are of the opinion that the values as derived through average of both methodology is closer to a likely transaction rate, as it captures the risk and return expectations of the various stakeholders in a real estate development. In our opinion, the market value of the proposed freehold interest in the land, assuming vacant possession, is not this 149.5, which is the average of the two they have done. So they're just valuing the land here. So this was the land part. Now the credentials are also part of the record. If I may just draw attention to, after this valuation, this firm company came forward to say that, well, we can also sell it for you if you give us a fee of 1%. And our broker's opinion of the expected sale price is about 190, between 187, 188 and 198 crores. So this is how we can get for you. So that proposal they had given, we didn't go with that proposal, but that gave us an idea of what to expect. So in that proposal, they have mentioned their the credentials. If my lords are pleased to see their credentials, kindly see at page the proposal starts at page 463, and kindly see at page 466. Cushman and Wakefield is the world's largest privately held commercial real estate services firm, founded in 1917. It has so and so. Then we'll kindly see the next page. Cushman and Wakefield is the world's largest privately held real estate found. This is the same thing. But kindly see 468. C&W India started operation in India in 1997. Then they're mentioning what they have done in India, 468, 469, 470. And then look at page 475, broker's opinion of sale price of the property. So that was a valuation as an expert. They're not registered values, that's a fact. It's a private company, they're not registered values. But they said that if we sell it, this is what we might get for you. Our opinion on sale price for the property, measuring 13 acres approximately, owned by Tata Global Beverages Limited at so-and-so, is between 14.5 crore per acre to 15.25 crore per acre, which translates into about 188 crores to 198 crores. Now, I ultimately made an agreement to sell and sold to a Tata Group company for 195 crores. So this was this second document is actually a broker's opinion. It's not an expert valuation. Tribunal says I have given two varying valuations. I've not given two valuations. I've given one valuation, and the other is a broker's opinion of the sale price. Normally, if I can take my lords to the tribunal's order. There are, of course, other things that I can show, because the buildings I got separately valued. My valuer took into account the fact that most of the buildings were constructed in 1964, 49 years old by that time. So he depreciated the value. The stamp value persons, they did not give any depreciation at all. So my valuation was 82 lakhs odd, their valuation was 10 crores, the stamp value. The stamp value for land was 220 crores, my value was 195 crores. This was within, this was about 13% difference, but the building, there's a very substantial difference because the
building depreciation has to be given.
Yes, they did not, I'll show from the record, they did not allow any depreciation at all. Now, kindly see the findings, if my lords are pleased to have, if my lords have volume 5 or from the memorandum of appeal, whichever
volume 5.
Lordship. Kindly take note at page 5. Page 624.
So the discussion starts only from
Yes, please.
এটা কোথা থেকে পেলো? It's a case of amalgamation. Tribunal এই ফাইন্ডিংটা দিচ্ছে না। Inter-se groups এর মধ্যে transaction is not entirely, but that's the one part. Share হয়েছে partly purchase হয়েছে। Page 5 not fair market value. Section 50 টা খোলো। ওটা যদি ওটা স্যারের বই না স্যারের বই এটা
Yes. Solution is given the borrow section is clear only to transfer of an super capital in land or building or both is less than the value adopted by SC or assessment by any authority of the state government. And the section number 2 is the stamp pollution authority for the purpose of payment of the stamp duty in respect of such as per the values adopted share part the section deemed to be the full value.
Listen, judges will come. So, मेरे पास copy है खाली इसका निकाल
Function of section 50 section now. One of the not জানি কোনো চাপ নেই আমিও বেরিয়ে দেখতে গিয়ে দেখলাম বাইশ হয় 23 হয়ে গেল দৌড়ে দৌড়ে ঢুকে গেলাম।
Thing has been considered.
No, I must just draw attention to that building part in volume 4 itself.
But he should have sent it to the DV, Department Valuation Officer. Once they have contested that.
No, the assessee also wants to urge the point that they have been requesting. So if the department, if it has now missed the bus, I'll be subjected to another round of proceedings. But the first thing is not to first sort out the factual part, not to write an order like this, not a lot of English, no reasons, even the commissioner appeals, not exactly like that, they don't discuss any of the documents. And the building part, kindly take page 520.
And this comment about the group company, big company, how they should maintain the building, etc., all uncalled for.
And that discrepancy of the year, in the sale deed, the building construction is 1964. The valuation report is 1964. In the stamp adjudications, they printed misprinted is 1954. So I bought it in 64, but there's no question of any construction in 54. But my records are clear.
All right, that is sufficient to refer it to the DVO.
One thing,
or you can do one thing, sir.
Lordship.
You make a small tabulated statement,
Lordship,
clearly indicating the page numbers,
Lordship,
on all the factual issues where mistakes have been committed.
Lordship.
And probably we can consider, and there's no point sending it back to the tribunal.
Because in the light of section 50C, the process that is required to be adopted, your lordship may only examine whether that process has been adopted by the authority or not.
See,
because
they discredit this particular valuation report primarily on two reasons.
Yes.
First, it is a foreign company.
Yes.
Second, it's not a registered value.
Mal.
It is up to the assessee to choose a value. They have chosen a person who are the pioneers in the field.
Mal.
And their presence in India, at least in 6 or 10 locations, has not been disputed. It is not the white man who came and inspected the property. It is their local officers who inspected the property. If you don't agree with that, then what is the option left to
there
the
is
assessing
also
officer?
another aspect of the fact that
In fact, they have made an alternate submission. Without prejudice to that, they have also said 50C will not be applicable.
Yes.
And this report should be accepted. And in the report, probably it's the methodology they follow. And there is a disclaimer in the report. If you see that, what is the purpose of valuation? That is make it 425.
But at page 459, my lord, may have seen it. Volume 4.
Four 459 is the caveats and limitations.
Yes.
426 in the general comment.
Lordship.
They say a valuation is a prediction of price, not a guarantee.
Well, there is another aspect, my lord,
All
which,
right.
my lord,
We have
tribunal has.
heard so and so. In order to facilitate the hearing of the appeal, the learned advocate for the appellant is directed to prepare a tabulated statement for pointing out the relevant factual details, the findings recorded by the assessing officer, the CIT, and the tribunal, and along with the page numbers and the volume numbers of the annexures to the stay application. By this process, the hearing can be expedited, and also it will add clarity. Let a copy of such tabulated statement be served in advance on the learned candy counsel for the appellant. Third September.
And then here,
One thing can be done is to send it back to the AO and asking him to refer it to the department valuation officer. The stamp duty, if you see all the decisions under the Stamp Act, there are, it may be a guideline. See, if you want to, get judgments which ignore the, the guideline value or the circle rate. What is it called in West Bengal?
Guideline value,
Guideline. The line of judgments under the Land Acquisition Act arising out of a reference under Section 18, invariably they will find out reasons to reject the guideline value. Because the guideline value will be more than certain cases than the market value. Then they'll add all this rider, etc. And an award will be passed giving 200 rupees per acre.
Because, my lord, the stamp duty, my lord, that is, my lord, decided is on the basis of the market value, my lord. The registering authority, my lord, being a revenue authority.
That is not gospel truth, I'm saying.
No.
It's an indicator.
It's an indicator. Because valuation, my lord,
decisions under the Stamp Act as to what is the effect of the circle rate or guideline.
here that assessing disputing the stand valuation order taken by the registering authority. There is a provision for challenging that. Here the assessing is not an ordinary big company. Instead of challenging that valuation before the assessing officer, that we could have challenged before the appellate authority. They have not challenged that valuation before the appellate authority. In Registration Act, my lord, if the buyers, purchaser.
No, their case was, if I have understood it right, if this was the dispute before the AO, he should have referred it, mandatorily referred it to the departmental valuation officer.
No, that provision stipulates that I should not have disputed in the stamp before the stamp authority. Then only I can seek this reference. Otherwise, I cannot. My learned friend says I should have taken that recourse and not.
My lord, there is a provision. I have challenged this kind of valuation.
There is,
the
of course,
registering authority had taken the market value, is my opinion, this is more than I had filed appeal before the collector.
No, that is a separate procedure.
That is because Section 47A under the Stamp Act provides for that.
Yes,
Rafi.
yes.
That itself is an indicator that the guideline value is only an indicator.
This is
Otherwise, what we can say is that we remove scrap 47A, whatever the government fixes every 2 years or every year, there will be an increment of 3%, 5%, 10%. And at times, what happens is, see, let us assume like Amphan, COVID. They have the same multiplier. Once in 3 years, the guideline has to be revised by 10%. They'll keep on increasing, but there is no money in the market. So the property will come at a throwaway price at 50% of what the guideline value stipulates. So you will can establish before the collector stamps under 47A that the apparent sale consideration reflected in the deed of conveyance is the actual fair market value of the property. Let us see. I'm ready. We'll stop looking at it.
My lord, we could switch over to the applicant side. Item number 31 and 32 and 33, my lord. There is a stay application. We have come before your lordship against the order of the learned single judge. I have taken 3 or 4 points, but one of the point very short and brief and is covered by the Supreme
And
Court.
who will appear for the respondent?
Tilak Mitra, my lord.
And what is the stay you want? 148 proceeding.
148 proceeding because the
one file. Kesoram Industries.
No, okay, not Keshuram, my lord. This is a stay 31, 32, 33.
Seri Insurance.
Seri Insurance.
What happened? Your writ petition was dismissed.
No, it is not dismissed. It is admitted, but learned single judge refused to grant any stay because the 148 notice already issued. But my case is, my lord, it is very fundamental issue that sanctioning authority has given approval without any reason, very mechanical, and it is very apparent. And as on date, there is a judgment of the Delhi High Court, and this is traveled to the Supreme Court, and Supreme Court with reason dismiss the SLP, my lord. And lordship kindly.
Where is the order passed by the single bench?
My lord. There is a 2 order your lordship should consider. First order 221 at page 221 of the stay application, and next is 233 against which I have come. My lord, kindly take first 233 and then 221. And before that 221 also to be considered, my. After 1 month, learned judge asked to produce the record. But from the order itself, that annexure with the 148 notice, I can show that the principal commission has given the approval totally mechanically in one line, my lord. And it is at page, my lord.
No. Show the notice. Have the furnished.
190 is the notice, my lord. And the relevant approval 202.
Wait. 190 is the notice. Where are the reasons for reopening?
Reasons for reopening and given, my lord. They have not given any reason at all. First of all, this is my one of the ground because my case is coming under the explanation 2 of section 148. In case of the third party search premises, they have directly issued the notice 148. It is permissible under the law. But my case is that there is a case of the satisfactions of the assessing officer, which should be have live link with the conclusion, and they failed to brought out any satisfaction. I can show from the annexure from the 148 notice. And my first question is that 148 notice issued on the basis of the approval given by the specified authority, because the first proviso says no notice can be issued without the approval of the sanctioning authority. And lordship kindly take the page 202. I will come to the reason. First 202, page 202, only one line approval. And on that point, there is a judgment of the Delhi High Court, which is carried to the Supreme Court. Supreme Court has dismissed their SLP with reason, my lord. This is which is binding upon the authority as on day. My lord, take on 202. That I am satisfied, last line, who's the sanctioning authority. I am satisfied with the case is fit for the issue of the notice under section 148 of the Income Tax Act 1961. So Kolkata may kindly approve the same. There is no reason. It is a mechanical approval. And there is a judgment, my lord.
No. This is typed, already they have typed.
They have typed
He put his signature only.
only. There is no reason. And on that point, there is a judgment of the Delhi High Court and Supreme Court also. That I want to show my.
Sir,
My
if
lord is taking up this matter.
No, no, if stay is not granted, writ petition will become
Well,
infructuous.
I shall indicate, my lord, the reason, my lord, the steps that has been required to be
My lord, this
taken.
is a Supreme
but
Court
that has
order,
been
first of
taken.
all.
Now,
Delhi High
the
Court
recorded reason whether, my lord, in respect of this particular assessment here, what was the?
No, if the writ petition was dismissed, that's a different ground.
And it is based on the Delhi High Court. हमारे क्या होता है क्या?
Mr. Basu,
Yes,
please
ma'am.
wait.
Yes,
I'm
sorry.
See, but the learned judge thought the matter has to be heard, file has to be called for. In the meantime, if you make the writ petition infructuous,
May I only say, my lord?
what the officer will do? He will proceed further, pass an ex
That's
parte
the-
order, 142 notice he will issue, complete the assessment under 147.
May I say, my lord, I am equally agreed with this order because, my lord, the writ petition should have been, my lord, dismissed on the threshold. Should have been dismissed on the threshold because, my lord, keeping the writ petition pending and, my lord, asking for the record to be produced and, my lord, then not passing any interim order as a counsel of this court, my lord, I do not support. But this does not, my lord, canvass any prima facie case because, my lord, the reason this has been, my lord, arises out of a search and seizure cases. So, my lord, one for
He is not the searched person. He is a third party.
yes, my lord.
What last week we delivered one decision.
Yes.
I think you have only appeared.
That is, my lord, on a
You-
148, 158 BC
Ah,
issues.
So therefore, how he has to record satisfaction? If suppose if the searched person, jurisdictional officer, and the assessing officer, jurisdictional officer, one and the same, the situation will be different. Here there are two different officers.
Different officer, I have taken this
So
jurisdictional
therefore,
point also.
the other officer should record satisfaction, then forward the papers within a reasonable time. When was the search conducted?
30th November 2022. And they issued the notice in the 2025, 27th of March.
There are 3 decisions in your favor. Entire thing is gone on account of delay. Where is the judgment?
But I believe, my lord, my learned friend has not taken this point. He was solely, my lord, question of jurisdiction, my lord. Maybe.
He will file supplementary.
I understand, but well, it was solely on the point that 148 AB was not accorded, 140 AD order was not passed, my lord. That is, he has actually, my lord, challenged 148.
We have heard the learned advocate appearing for. Where is the Bombay High Court judgment?
Bombay High Court, that jurisdictional officer and
No, satisfaction.
satisfaction on the point of satisfaction, my lord, I have not taken on the point of satisfaction.
Yes, this is
Delhi High Court judgment.
This is Supreme Court judgment.
At Delhi High Court, I have given, my lord. Oh, and this is the Delhi High Court judgment, not Bombay, my lord. But my lord, the entire submission was on the point of nexus, live nexus with regard to, my lord, the materials that has been collected with the SSC.
Sir, there is nothing except the signature in Hindi. What is the name?
Name of the official, my lord.
In the signature.
Name of the official, I cannot. But this has been, my lord, this has been forwarded to him. So, my lord, this is, my lord, the reason on the basis of which, my lord, this has been initiated. My lord, whether the question that has been forwarded to the SSC or not, this has been forwarded to him. He has made a part of this, my lord, recorded reason. He has made it a part of the writ petition. And, my lord, the reasons, my lord, that is appearing on the document, my lord, is elaborate one, my lord, indicating, my lord, the involvement of the SSC with the incriminating materials.
All right. Let there be a short stay. These intra-court appeals have been filed by the writ petitioner, being aggrieved by the order passed by the learned single bench, dated 7th August 2025.
27 March, my lord, 2020. Yes, 7th August, sorry, my lord, 7th August of 2025.
2025, by which the learned single bench opined that there is no scope of granting any interim order, especially having regard to the fact that notice under section 148 of the Act has already been issued. The learned single bench was of the view that records has to be produced by the department. So therefore, and the matter requires to be considered. The appellant had filed the writ petition Now, where is the copy of the writ petition?
Copy of the writ petition, my lord, at page.
My lord, it starts from page 57 of the stay petition, I believe.
At 54, my lord, annexure A. At volume 1, my lord. And relevant grounds.
Where are the grounds?
Ground starts from page 97, and about this.
In the grounds, my lord, entire facts has been depicted. If your lordship kindly see.
Page 104, that ground number 8, 7, 8, both.
Wherein several grounds have been raised by the appellant writ petitioner, among which one of the grounds is that the powers vested with the authority under section 151 of the Income Tax Act 1961, within bracket the Act, to grant or not to grant approval to the assessing officer is coupled to the condition that the authorities are duty bound to apply their mind and cannot exercise it casually in a routine manner. The appellant contended that it is apparent from the annexures to the notice issued under section 148 of the Act, sanction for issuance of notice has been issued in a perfunctory manner. And to demonstrate the same, the learned advocate for the appellant has drawn our attention to the said annexure to the notice issued under section 148. And prima facie it is seen that the Chief Commissioner of Income Tax has affixed his signature and no reasons appear to have been recorded. Apart from that, it is submitted that the notice has been issued after more than 2 years after the search was conducted on the searched person, and this is also one such illegality.
In my premises, search has not been conducted. Third party's premises. And they have not taken any reference of my name also.
The Act uses the expression searched person.
Sir.
You are the third party.
No, my lord, in my premises, search has not been conducted.
Search person is somebody else. You are the third party. As the learned writ court was satisfied that the records have to be called for and the matter requires to be considered, in our view, if the department proceeds further pursuant to the notice issued under section 148 of the Act, the writ petitions would become infructuous. Therefore, the appellant would be entitled to grant of appropriate interim orders. Accordingly, till the writ petition is heard and disposed of, the respondent authority are directed not to proceed further pursuant to the notice issued under section 148 of the Act and abide by the result in the writ petition. In the event the appellant is unsuccessful in the writ petition, the authority is entitled to proceed further in the matter, and the appellant cannot raise the question of any limitation during limitation on account of the pendency of the writ petition. With the above observations, the Appeal stands disposed.
Lord, may I only prefer a modification instead of, my lord, producing the record? That will be a huge task. May I, my lord, just take out an affidavit in opposition against it?
It will be well open to the respondent department but the learned judge has recorded them, to file their affidavit in opposition and annex the copies of the relevant records.
My lord. 32 and
My lord.
33 also same, my lord. Only
32
the
and
different
33 also
assessment here. My lord, only one mistake we have done in the spelling of the read petitioner. That is the Sri
31, 32, 33 same.
Same. Sir, my lord, only the booking, instead of broking, it should be broking. So I have made the prayer in my application also. The name of the read petitioner may be
The
corrected.
appellant is at liberty to correct the mistake which has occurred in the name of the appellant writ petitioner, both in the appeal and the writ petition.
Read petition. Both the appeal and supplementary affidavit also, because I have filed one supplementary affidavit.
All you commit
My
a
lord.
mistake and the court wants to.
My lord, a small indulgence, my lord.
You add the learned advocate appearing for the appellant writ petitioner place reliance on the decision of the Honorable Division Bench of the Delhi High Court in TIA Enterprises Private Limited versus Income Tax Officer 2024 468 ITR 5 within bracket Delhi. Wherein it was held that the approval granted by the statutory authorities for reassessment proceedings under section 147 of the Act, as required under the provisions of the Act, has to be furnished to an assessee along with the reasons to believe that income has escaped assessment. Full stop. The statutory scheme encapsulated in the Act provides that the reassessment proceedings cannot be initiated till the assessing officer has reason to believe that income which is otherwise chargeable to tax, has escaped assessment, and reasons recorded by him are placed before the specified authority for grant of approval to commence the process of reassessment. In the said case, the copy of the alleged approval by the principal commissioner was not produced. However, in the case on hand, the annexure to the notice under 148 contains the approval, and as observed earlier, we are of the prime facie view that there are no reasons recorded by the principal commissioner. However, this finding is only a prime facie finding to support our conclusion that the appellants would be entitled for an interim order till the writ petition is heard and disposed of.
My lord.
I'm get one.
My lord, a small indulgence, my lord. Today morning it was mentioned, my lord, this is a Jalpaiguri matter. My lord, I want to file a appeal before this bench because the client has already traveled, my lord, and he's waiting, my lord.
He can go around Calcutta now.
No, my lord.
There are a lot
The
of
only
places.
difficulty, my lord, these are perishable goods, my lord.
Once mentioned, rejected, please don't.
My lord, the only difficulty that they have already booked their ticket back to Bihar and Assam, my lord. That is the only difficulty, my lord.
Sorry, madam. Please excuse us.
My lord, this is an appeal, my lord. And the certified copy is not available, it will be mentioned on Monday, then it will take a
Suppose the
week's
circuit
time, my lord.
bench becomes a permanent bench, what will you do?
My lord, I understand, my lord. Then the difficulty that after 15 days there will be another gap of 1 week. That won't be.
You go to Jalpaiguri. Next, please call.
Appellate side, daily list, serial number 1, 2, 3.
Lordship, at the very outset, the order, in the last order, I made a mistake, Lordship. I had said 7 September was the Rare Disease Day. It is actually the World Duchenne Muscular Dystrophy Day.
Doesn't matter. You celebrate someday, that's all.
This is not a celebration.
It's not a celebration in the sense recognizing, prioritizing such people.
Lordship, if your Lordship direction is taken up, my clients have actually ordered 10 wheelchairs. This is the invoice. And this is the payment. In fact, we have been given a little additional discount by the manufacturer, which is good.
When they will supply?
Lordship, on 7th September, we are holding the World DMD Day. That is the day when before that we'll get the stock and we'll be handing it over to the patients on that date.
7th September.
7th September.
And Madam I got the information, sleep study, cost
One
of the
second. We have heard so and so. With regard to the supply of wheelchairs to the persons affected by the rare disease, Kama the learned advocate appearing for the petitioner in WPAP 20 of 2020 submitted that order has been placed on the supplier, Messrs. Home Hospital Private Limited, for 10 wheelchairs, and payment has also been effected, and the wheelchairs will be supplied and they will be distributed on 7th September. Yes. Now, which are the UDID? The UDID, that issue.
For the
Mr. Mukherjee,
That was,
Malad.
Mr. Mukherjee
that
was
UDID problem was there.
UDID problem that now I had to cut with the health secretary because central government permission is necessary. If because now not about
at least you produce some written instructions.
No,
Then
but
we can test the
but
correctness.
we have got only a sleep study. Sleep study cost of machine is about 30 lakhs. And so far as
Lordship kindly takes it up page by page so that every aspect could be covered. I have underlined the portions. They were all kindly comes to page 5. The state government has to fix strict timelines within which the process will be completed after surrendering all UDID cards in cases where person of disability increases. That is the first paragraph of page 5. So they were supposed to ascertain what is the time limit, because we will be surrendering one card and your lordship knows that if the next card does not come within
Any
that.
officer is there from the department?
No, but nobody. No, but one
You
officer has
sorry,
from only
I think your state is not taking the matter seriously.
No, but just now I've got the information. But so far as sleep studies machine is assessed got about 30 lakhs, and but so far 2 days. Instead of one day per week, we have decided to take 2 days in the hospital. Routine medical test.
So 2 days has been accepted, and approximate cost of the equipment is 30 lakhs.
30 lakhs.
And you buy, what is wrong? How much is the amount you have given per Puja Pandal?
When I just heard from a newspaper, 1,10,000 per
Oh, Mr. Mukherjee, how you can rely on newspaper? You are senior state government council.
1,10,000 per club.
1,10,000 per puja.
And 30 lakhs is big money for you.
But normally for appearing for the government, but I can say, but can you direct the finance secretary to sanction this amount?
Wait, madam, where is this? Which paragraph you have dealt about that sleep study?
Lordship, at the very end. Kindly comes to page 9, paragraph 12.
In our order dated 13/8/2025, in paragraph 12, we had mentioned about the installation of sleep study equipment along with BiPAP machine. And in which paragraph we said about that it should be OPD should be increased to 2 days?
Lordship, that is at paragraph 10, page 8. Lordship, in this regard, I was just got the instruction. One patient, Pritha Pyada, she died. That is because she was brought into PG hospital. She was admitted into the emergency, but since her ICU bed could not be provided, she passed away within that space of time.
No, five.
Five.
In the same order, we had also suggested for increasing
From 2 to 5, 3 to be kept for muscular dystrophy patients and 2 for other rare disease patients.
Total 5. করতে বলে দিয়ে আর কি বলবো 5টা বেড
that the state government shall consider to increase the clinic to at least 2 days in a week.
Oh, that is it.
The professor, Department of
page 7.
Neonatology, Nodal Officer -COE of Rare Disease, IPGME and R -SSKMH, Kolkata, has given a report dated 27/8/2025, wherein it has been stated that the day of rare disease clinic at COE may need to be increased from 1 to 2 per week, provided the additional staff are appointed from the Department of Health and Family Welfare, Government of West Bengal, to the COE to run the OPD. Full stop. The activities of multidisciplinary rare disease clinic are in addition to the routine clinical duties of the faculties of COE, IPGMER, Kolkata. In the light of the above report, we direct the government, Principal Secretary, Department of Health and Family Welfare, Government of West Bengal, to provide additional staff to the COE for increasing the number of OPD days. This allotment shall be made within 15 days from the date of receipt of the server copy of the order. Full stop. With regard to the sleep study equipment is concerned, it is stated that the approximate cost of the equipment is rupees 30 lakhs. Full stop. The Principal Secretary, Finance Department, Government of West Bengal, and the Principal Secretary, Department of Health and Family Welfare, Government of West Bengal, are directed to provide appropriate orders of sanction, sanctioning funds for the purchase of the sleep study equipment, along with BiPAP machine, to be installed in the hospital, and this may be prioritized and requisite sanctions be made at the earliest, but not later than 15 days from the date of receipt of the server copy of this order.
Your Lordship, the next point that was taken up, Your Lordship had directed taking a figure of 500, whether the state government could, they were supposed to file a report in the form of an affidavit. That is at page 6, Lordship, the last 3 lines. Approval. 5,000 rupees to be taken for the moment that there are 500 patients. That amount was to be.
File has been placed before the Finance Department. It will be taken up. Government is considering, just have received a SMS message, but kindly direct Health Secretary to initiate, take steps on a date within 7 days.
Lordship, here also the finance will be involved. Not just the health secretary. Even if the health secretary allows it, the finance department has to give its consent.
On 2 previous occasions, has made a suggestion to the state government to provide a stipend of rupees 5,000 per person suffering from rare disease. And considering the total number of persons who have been registered in the portal, the court suggested that the approximate number of persons can be fixed at 500 and funds may be made available. Mr. Mukherjee, learned senior counsel appearing for the state, submitted that the matter is under active consideration of the Finance Department. It needs to be pointed out that though an affidavit, a report in the form of an affidavit was to be filed by the appropriate authority of the state. No such report has been filed. The Principal Secretary, Department of Health and Family Welfare, Government of West Bengal, and the Principal Secretary, Department of Finance, Government of West Bengal, are directed to take note of the recommendations made by this court and take serious note of the recommendations made by this court, and appropriate sanction orders be issued, and same shall be placed before this court. Sanction orders be issued within 15 days from the date of receipt of the server copy of this order, and the same be reported before this court on the next date. Then,
Lordship, may I pray that the whatever the secretaries are deciding, it would come in the form of an affidavit as your Lordship's direction, because otherwise it will just carry.
as long as things get done, it is all right. Affidavit means they will take their own sweet time to draft it. Then he will be lying in his table. Then affirmation. Don't stand on formalities. As long as the work is get done right.
Lordship, kindly comes to page 9, paragraph 11.
Then UDID, what is it?
UDID, Your Lordship, regarding the UDID matter, Mr. Gupta is appearing. He is out of town. On the next day,
We are asking Mr. Mukherjee.
UDID, Mr. Chakraborty, help us so that we can.
Mr. Mukherjee should apprise us. Mr. Mukherjee should apprise us what is the difficulty they are facing about UDID.
He doesn't know, sir, what to do.
And this issue of placing all these matters in settlement portal was taken up by your lordships long ago.
In
And
fact,
in the meantime, no objection has come up. No difficulty has been brought to your lordships' notice.
National Solicitor General সাহেব অসুবিধা যেটা হয়েছিল 75% বলে আগেরবার ইউটি কার্ডেতে দিয়েছিল disability.
We are thoroughly disappointed
90%.
that the state
সেটা
government has
change
not
করার জন্য
given
যে
us any information
surrender
with regard to
নতুন কার্ড
the directions / observations and difficulties faced in obtaining UDID cards and other related matters. It appears that the concerned authorities are not taking the matter seriously, and they need to be reminded that if orders are not obeyed, the court will be entitled to suo motu take action under the Contempt of Courts Act, which may result in unpleasant and adverse consequences. Therefore, the appropriate authority of state government are directed to respond to the observations made and directions issued by this court in its order dated 13/8/2025 with regard to the UDID cards on the next date, failing which the court may be constrained to initiate action under the Contempt of Courts Act.
Lordship, the same direction may be passed with regard to paragraph 11 at page 9. That this trouble we are actually facing, this child also died because lack of a ICU bed.
Equally, we are also disappointed with the fact that no action has been initiated with regard to the proposal to provide 5-bedded ICU unit in the Kolkata Police Hospital in the ground floor. We had in paragraph 11 of the order dated 13/8/2025, it was observed that the Principal Secretary, Government of West Bengal, Health and Family Welfare Department shall examine the aspect, and a request was made to the Principal Secretary to give his personal attention to this matter so that the 5-bedded ICU unit is established. No instructions have been given to the learned advocate appearing for the state. All that we can express is our disappointment. Let the matter be listed on so and so date for further directions.
Lordship, kindly.
Madam, what you do is
Lordship.
you ask somebody to get a copy of all the orders compile it date-wise. The earliest order will be in the first document and prepare a ready reckoner. Date of order, gist of the direction, compliance. Then only the next bench will be able to. It will be better. True.
Lordship kindly fixes a date before your Lordship demonstrates.
Oh, nothing will happen. They
Your
are not
Lordship,
taking it seriously.
Your Lordship, I will do what I have to do. Lordship kindly gives what date.
11th September.
I'm grateful to you.
Serial number 4.
Your Lordship has recorded that we shall be dispersing the wheelchairs on
7th.
Did I appear for the petitioner? But shall I submit?
Where is Mr. Vipul Kundali?
Mr. Kundali.
My lord, in this matter, the senior advocate, Mr. Vipul Kundila, is appearing, but he is engaged in the other court. That's why I am praying not today, my lord.
Not today.
Number 5.
But I am appearing for the petitioner.
Here who will appear for the department? Tanai, sir.
The Tanai is there.
What is this?
My lord, the issue in this petition is that my lord, my ITC has been denied on the basis that my supplier is non-existent.
Your writ petition was dismissed.
Dismissed. My lord, on the point of the non-existence, my lord, this particular supplier was registered with the VAT department even much prior to the GST came into force. My lord, this particular supplier, my lord, and he is an individual. So there is no question of an individual. There may be a private limited company or my lord, those kind of fake my lord, my lord, paper companies and all that, which the department may say non. But an individual, my lord, who was registered with the VAT department much prior to the, my lord, the GST coming into force cannot be said to be non-existent at least. He may have done some wrongdoing. But as far as I am concerned, my lord, all that I am requesting to the department repeatedly, my lord, it is a second, my lord, I'm coming, my lord, before your lordship. In the earlier, my lord, the instance, your lordship had remanded back the matter to the authority for cross-examination of the supplier and one of the transporter whose statement was the basis of the denial of the ITC to me. But there were 28 transporter who supplied the goods to me. They issued so-called notice on the basis of, my lord, statement of one supplier, the supplier in question, and my lord, the transporter. My lord, thereafter the cross-examination was done. In the cross-examination, the supplier gave a affirmative, my lord, response that he indeed supplied the goods to me. Now, my lord, immediately after the cross-examination was done, the authority concerned said that I will re-examine him to undo what has already been achieved through the cross-examination. So, since the direction was only for the cross-examination, we did not participate in the re-examination process. We participated in the cross-examination because that was the direction of your lordship. And in this regard, my lord, I will, my lord, later on, my lord, I will praise the judgment of one Supreme Court also that the re-examination in a civil matter has to be, my lord, in a very, my lord, rare circumstance. That has
Where is the adjudication order?
But just allow me 2 minutes, my lord, to frame my submission, my lord.
No, see,
No, my lord.
once we did it, you file an appeal, sir. How to examine all these things?
49, my lord. No, my lord, we will file appeal, my lord. Kindly, my lord, we will file appeal, my lord. My lord, one jungle. My lord, kindly.
No. What we will do is we will adjourn the matter by 3 months. That's all.
No, my lord, kindly.
The pendency of the appeal will not be a bar for them. What to say?
My lord, kindly hear me for 1 minute. My lord, what I am seeking a remand back only, my lord. Kindly hear me, my lord, for 1 minute, my lord.
Remand means we need to go into it. Sufficiency of evidence, whether the opportunity was granted, what did the other fellow say about it, whether this.
No, my lord, I am not asking your lordship to go into that, my lord. My lord, my only request is that, my lord, your lordship had given me two, my lord, on 2 grounds it has been remanded back. One,
we committed a mistake in doing.
No, my lord, kindly hear me for 1 minute, my lord. Other was, one lord, to verify the movement of the goods. My lord, as far as the verification of the movement of the goods, my lord, we have purchased the goods within a short vicinity of 8 kilometers and we have sold all the goods interstate, my lord. With respect to interstate transaction, my lord, in 2029, there was a press release by the government of India that the fast tag has been integrated with the e-waybill system. And once that integration is done, the purpose was to verify the movement of the goods. And on the basis of that integration of the fast tag, my lord, the movement of the goods can be verified by the department. The department has been repeatedly issuing so-called notices to various, my lord, the SSCs with respect to reversal of ITC, that we have verified the portal, your goods has not moved. You are claiming that it has moved from Haryana to West Bengal, but the fast tag report is showing that there is no movement. As far as I am concerned, my lord, I submitted the fast tag detail of 2 vehicles. With respect to the rest of the vehicles, my lord, I requested the department that kindly generate the report and make it a part of the investigation process, because the evidence which can help me to discharge my liability or the burden of proof, the department cannot say that I will not help you with that part. It is with the department. It is not that the department is not in possession of that particular document which I am unable to log in into. The portal does not allow me. Correct. So all that I am seeking, my lord, is that, my lord, this movement of the goods, which is my lord, the most important part of the.
You rightly said so. You cannot get into that portal, but as a dealer, what you can produce is prima facie documents to prove movement of goods in these vehicles. The moment you submit that, let us say e-waybill,
I've submitted that, my lord.
so he will cost the verification. If that verification is done, not done, properly done, half not done, how to examine?
No, my lord,
my lord,
I cannot.
You know the code. If there is an illegality, irregularity, even if it is a 300-page order, the court has set aside. In certain issues, we have to draw a line. So it definitely requires examination of facts.
No, my lord,
file it before the committee.
All the time, my lord, all the time saying is that, my lord, this movement of the goods, my lord, which is the, my lord, only thing which can save me from the allegation that my transaction is fake. So, my lord, I am saying that this, my lord, I have submitted the fast tag movement report of 2 vehicles, my lord. I am seeking report of the rest of the vehicles which has been used for the movement of the goods, my lord, for the transportation of the goods. That is all I am seeking to, my lord, save myself, my lord. There is nothing else which I can do, my lord. I can furnish the e-waybill, I can furnish the my lord, the invoice, the bank statement and everything. But the report which is not in my possession, which is in the possession of the department, my lord, they have to furnish that report, my lord. That is all that I am seeking, my lord, at this junction.
See, the problem is that a remand order has worked prejudice to you. Those 2 fellows came and deposed against you.
No, my lord, the supplier deposed in my favor. The officer is saying that he is mentally incapacitated to say that he supplied the goods to me. My lord, how can they make a personal, the officer make a personal remarks against the supplier just because he has given an affirmative statement in my favor that he indeed supplied the goods to me? But in the order, the officer records that he is mentally incapacitated to give any deposition that whether he supplied the goods or not. This kind of personal remarks are, my lord, not, my lord, something which should have been made, my lord. Maybe the officer may come to any conclusion.
Now there are personal remarks and judgments also.
Yes, my lord.
The writ petitioner.
My lord, kindly, my lord, kindly.
We will protect you, harm you with all. But writ petitioner is the appellant before us, having been unsuccessful in the challenge to an order of adjudication dated 24/7/2024. On an earlier occasion, the appellant had approached this court and an order was passed in an order was passed
205. My lord's
in
order is
MAT 854 of 2024, dated 7/5/2024, remanding the matter to the adjudicating authority with certain observations / directions. Upon such remand, the adjudicating authority has conducted de novo adjudication and passed an order of passed the order dated 24/7/2024, by which the authority has levied tax, interest and penalty under the provisions of the CGST/WBGST Act. Admittedly, as against the order of adjudication order, the appellant has an effective alternate remedy of filing an appeal. The learned advocate appearing for the appellant would tenuously contend that with regard to the movement of goods, the appellant was able to produce documents which were available at their end, but however, the details as recorded in the fast tag portal cannot be accessed by the appellant, and in this regard, the department ought to have cooperated with the appellant and provided necessary details. Furthermore, the learned advocate has also sought to canvass certain grounds as regards the effect of the statements given by the supplier during the cross-examination, etc. In our considered view, to test the correctness of the impugned order, facts have to be adjudicated, much of which is being disputed and denied by the department. Therefore, we are not persuaded to exercise any discretion in this matter, since the remedy provided under the appellate remedy provided under the Act is not only an effective remedy but an efficacious remedy as well. The appellate authority will be able to appreciate the factual position. If necessary, he can call for records and also direct his office to access the FASTag portal, etc. And all such prayers and all grounds raised by the appellant can be canvassed before the appellate authority, which will be considered by the appellate authority after effective opportunity of personal hearing to the appellant. Therefore, in considering the facts and circumstances of the case, the appellant should not be permitted to bypass the statutory appellate remedy. Therefore, we are not inclined to interfere with the order passed by the learned single bench. Accordingly, the appeal is dismissed with a direction to the appellant to file a statutory appeal before the appellate authority, and if such appeal is filed within a period of 60 days from the date of receipt of the server copy of this order, the appellate authority shall entertain the appeal without reference to limitation and subject to other compliance of other conditions. The appeal by other conditions by the appellant, the appellate authority shall consider all grounds which that may be canvassed by the appellant and the documents submitted by them, and after affording an opportunity of personal hearing to the authorized representative of the appellant, pass a recent order on merits and in accordance with law.
Only one request, kindly give a positive direction with respect to the furnishing of that movement report for FASTag. Otherwise,
The
again,
appellant will be entitled to make a specific request to the appellate authority with regard to the FASTag details, which according to the appellant is a very vital document. This aspect shall be canvassed by the appellant before the appellate authority, which shall be taken note of in accordance with the law. Next.
600 pages, 669 pages appeal. But I said on the previous occasion, can be no less than 600. Whatever documents are there, I have to enclose it.
Serial number 6.
Mr. Cordelia is there. Oh, yes, come.
He was not there.
Yes, earlier. Now,
what is this? I got a little delayed.
Your Lordship, before going into the factual matrix of the case, I would like to just put on what are the major points of law which I wish to plead before Your Lordship. Your Lordship, the first point which I wish to plead is that once a particular discrepancy has been dropped by the department, can the same department issue a show cause notice with respect to the same discrepancy which has already been dropped by it? That is the first point. Second point, Your Lordship, is whether there can be multiple assessment for the same cause of action pertaining to the same year. And third, Your Lordship,
By two different authorities.
no, it's by the same, it's by the central authority. It is by the central, the same authority. The third point, Your Lordship, which I wish to argue before is that whether section 74 in the instant case could have been at all invoked. Now, coming to the factual matrix of the case, Your Lordship, I am a subcontractor. My principal contractor had entered into an agreement with JSW Steel for its plant located in Karnataka for work related in its plant. The contractor had subcontracted a part of work to me. Now I had subcontracted this work to this particular supplier, where an allegation has been run that I have availed ineligible ITC from it. Now, to this effect, Your Lordship, kindly see page number 102. JSW itself has also given a certificate to this effect that the principal contractor, he was indeed engaged and the work was completed by it. This appears in page number 102, Your Lordship. Shall I read, Your Lordship?
Successfully execute. No, he is your subcontractor.
No, he is the principal contractor. He has given a subcontract to me.
So
and
therefore,
now
the company has certified that the principal contractor has completed
the work.
Very good.
And I have further subcontracted it to the supplier in question. Now, Your Lordship, I was issued with a discrepancy in GST ASMT 10 for the financial year 2018-19 under section 61, Your Lordship. This was for the scrutiny of returns. It appears in page number 113, 31st of January 2023, Your Lordship. If Your Lordship kindly sees paragraph number 3, on scrutiny of the GST returns, it is observed that you have availed ITC amounting to rupees so and so during the financial year 2018-19 on the strength of invoices issued by Messrs. Dhanasha Infracon Services Private Limited. Now, this is the particular supplier with which the show cause notice was issued and an order was confirmed. After this, Your Lordship, I have duly replied to this particular notice, which is in page number 116, Your Lordship. It starts from 116. I've given all the details to the about the supplier in question, GSTR 2A TDS certificate, everything, Your Lordship. And then after this, Your Lordship, the department has dropped this particular discrepancy that is in page number 128, Your Lordship.
No further action is required. Very good.
Now, Your Lordship, I had applied for the cancellation of my GST registration after this. Post that, the department issues me an intimation for the remaining financial years, which is 2018-19, sorry, 2017-18, 2019-22, 22-23. That intimation, Your Lordship, appears in page number 123. Prior to. And Your Lordship, I had applied for the cancellation of registration on the 4th of February 2023. This intimation was issued to me on the 7th of March 2023. Even here, Your Lordship would see in paragraph number 3, it has been alleged that you have availed ITC amounting to rupees so and so during the years during the financial year 2017-18, 19-20, 2021, and 21-22 respectively on the strength of your invoices issued to your suppliers, namely Messrs. Dhanasha Infracon. There are 2 other suppliers, but they have not confirmed, but they have not raised any demand in the show cause. Now, I also reply to this, Your Lordship.
On the ground that their registration has been cancelled.
Yes.
Retrospectively.
This was even earlier to this, on 31st of January for financial year 18-19, they had also issued with respect to this Dhanasha Infracon, to which I had replied.
They dropped the proceeding.
They dropped the proceeding for 1 financial year. They had scrutinized whatever documents I have submitted them, proving the genuineness of the transaction, and they had dropped it. Now, I had replied to this intimation as well on the 14th of March, which is in page number 129, Your Lordship.
Where have you said that in respect of one financial year, this has been dropped? You have said that they received supply when the registration was valid.
Thereafter, they had cancelled their registration, Your Lordship. The order for cancellation of registration
is 133.
I think that was not raised. That
130
issue for one financial year.
we have raised it in the show cause. When the show cause had come, we had specifically communicated.
No, in the reply to the intimation, it has not been.
In the reply to the intimation,
it is not there. All right, proceed further.
But they cancelled it, probably being satisfied with the.
but after this, Your Lordship, they had cancelled my GST registration.
Page 133.
Which is in page number 133, 16th of March 2023. Now, Your Lordship, after a period of 1 year, they issue me an email, 1st of August 2024, Your Lordship. They give me an email which is in page number 134. And then they said that as per alert circular number so and so, issued by the Joint Commissioner against Messrs. Dhanasha Infracon Services Private Limited, it is found that the taxpayer is non-existent at the registered place of business. The said company has issued fake invoices. In this regard, I am directed to inform you that Messrs. Dhanasha Infracon Services Private Limited had passed fraudulent ITC during the period August 2017 to May 2018 to the tune of so and so. To you, despite being a non-existent entity, you are therefore requested to reverse the amount.
17, 18 or 18, 19?
Your Lordship, this is only for August 17 to May 18, this email. I replied to that email as well, Your Lordship, which is in page number.
Where is the email? Page 151 is the show cause.
Page 134 is the email, Your Lordship. 134. Then Your Lordship, they issue me the show cause notice. It was in page number 151. Your Lordship had pointed. Your Lordship, this is only for 2017-18 and 18-19, Your Lordship. Now, 18-19, Your Lordship, was already dropped by them with respect to the same supplier in question. They had dropped it previously. Now, they add this in this particular show cause notice, which they had already dropped.
But this show cause is after your cancellation.
This show cause is after my cancellation, Your Lordship.
On the basis of alert circular.
And this, Your Lordship, the show cause notice has only been on the basis of alert circular, the date of which dates to September 2024, Your Lordship. So they already had this knowledge, the fact that Dhanasha Infracon, they might be engaged in some bogus transaction. They had this in knowledge. That was the basis of the issuance of GST ASMT 10, which was the notice under section 61, which was issued to me.
Intimation.
The intimation. They had this knowledge. So to say, Your Lordship, to the entire show cause is today it rests only on the alert circular, Your Lordship, and nothing else. There is no investigation.
What is the reason they gave for the extended period of limitation? They have invoked the extended period.
Fraud.
That's in Your Lordship 154. The allegation is of willful misstatement and fraud, Your Lordship.
There is no fraud from my side.
Your Lordship, in this case, there is no fraud from my side. Even in under section 74, Your Lordship, I'll be having two limbs argument. First is Your Lordship has held in categorical in many judgments that if the department has slept over its own right to issue the show cause notice in the normal period, the department cannot be permitted to issue show cause notice within the extended period of limitation as well. That is the first point to it. The second point to it, Your Lordship, is that, Your Lordship, when I had conducted the transaction with the supplier, which dates back to 2017, 18, 19, the supplier was valid. It might be that supplier may have engaged in some bogus transaction with some other entities. But as far as my case is concerned, and that is also much later to the
No, the
period.
cancellation of their registration was later than, I mean, subsequent to the
Transaction.
before the show cause notice.
Show cause, the cancellation was before the show cause notice, Your Lordship.
No, they referred to the date somewhere I saw. But on the date when they gave you the intimation at page 123, the registration of the suppliers were cancelled or was it valid? You see the intimation 123. I think that's where they say
It was cancelled with effect from 2/7/2017. Yeah, with effect from 2/7/2017.
When was it? So it's a case of retrospective cancellation.
It is Your Lordship.
Own judgment.
But Your Lordship, your own judgment says that merely if a supplier's registration has been cancelled.
In your reply
Yes, Your Lordship.
to the show cause notice, show cause is at 151. Where is your reply? 161.
Yes, Your Lordship. It starts from Your Lordship.
Where have you raised this point?
Your Lordship, in the grounds, Your Lordship, I had raised it. If Your Lordship comes to Your Lordship, will kindly come to page number 173, Your Lordship. Point number C. And point number D, Your Lordship. Form GS. May I read, Your Lordship? Page number 174.
Concealed registration वाला point पूछ रहे हैं.
पहले first में jurisdiction था. I've also cited, Your Lordship, the judgments of Suncraft, Gargo Traders to put forth this point.
So major points are three. One is that extended period could not have been invoked. Second is for the same financial year, one issue which was raised, reply given, satisfied, proceedings dropped.
Your Lordship, if
Number three, retrospective cancellation of the registration of the supplier cannot affect your right to avail ITC.
Yes, Your Lordship.
And what happened to, where is the adjudication order?
The adjudication order, page number 85, Your Lordship. It starts at page number 85.
Page 94.
Your Lordship, the operative clause is from page 94.
Paragraph 9.
How does he deal with your this issue where you said the same issue has been
That's
dropped?
in page number 96, Your Lordship. For the financial year, I offer my comments to both the assertions as follows. For financial year 2017-18, in case of proceedings under investigation for financial year 2017-18, the allegation in the ASMT 10 issued by the jurisdictional range superintendent stems from the allegation of availing ITC amounting to rupees so and so. I find that the same allegation has been leveled in the impugned SCN. It is pertinent to mention here that the taxpayer claims relief against proceedings for financial year 2017-18 on the grounds that the jurisdictional superintendent had issued REG 19 order for cancellation after being satisfied of their submissions against the ASMT 10 for financial year 2017-18. However, section 29(3) of the said act states as follows: the cancellation of registration under this section shall not affect the liability of the person to pay tax and other dues under this act or to discharge any obligation under this act or the rules made thereunder for any period prior to the date of cancellation, whether or not such tax and other dues are determined before or after the date of cancellation. Further, the circular number so and so dated 26/10/2018 states the following, Your Lordship, then, and for financial year 2018-19, he does not deal with the factual matrix at all. He simply goes on to say, now coming to the issue.
He does not refer to dropping the proceedings, page 128. 128, he had dropped the proceedings.
Yes, Your Lordship.
Superintendent range 3, this has reference to your reply 13.2, found to be satisfactory, no further action. But he says that section 29(3).
Section 61 proceedings, not one.
Your Lordship, if
what does 61 say?
Scrutiny.
Scrutiny of the returns. Your
Scrutiny
Lordship.
of returns.
May,
It's only scrutiny of returns, which is what the trial court went on. That was the point that was urged there. It was held, my lord. My lord will kindly see.
No. Maybe earlier there was an intimation for which reply was given. The reply was found to be satisfactory, and the matter was proceedings were dropped.
Thereafter, the alert circular came much later.
That
came much
can
later,
you,
which is why section 74 proceedings were drawn against.
How it can be done?
Because at that point of time, the fraud had not been unraveled. When the fraud got unraveled, which is why...
No, don't say fraud. It's a very serious expression. According to the officer, the allegation of fraud means that supplier's registration was cancelled. If the cancellation of his registration was retrospective, then the law is in their favor. And number one. Number two, how do you invoke extended period of limitation?
My lord,
there should be an allegation of fraud on the part of the taxpayer.
My lord,
that by the other man.
My lord will kindly see the show cause notice once then.
Yes, we'll see. Page 151.
151.
You straight away come to that
155.
paragraph.
155.
155.
Yes, my lord.
From the facts and circumstances, it appears assessee resorted to unlawful manner of procuring fake or bogus invoice without actual supply of goods and willful suppression of facts.
Because he was found non-existent.
Maybe, but he. Therefore, that is why the concept of cross-verification.
Yes.
Had been brought in.
Yes.
So there the dealer has to be put to notice, saying that, see, look here, he is supposed to be a supplier. You availed X amount as ITC, but that jurisdictional officer has cancelled his registration on the ground that the supplier was not found. He can't have access to your portal. If, according to him, once he puts that GSTR2 or some return, the other return is auto-populated. 2A is auto-populated. He doesn't have control over it.
Yes.
That is enough to prove his side. If you want to prove him wrong, you have to put him on notice with the other man's allegation. And there is no allegation against the appellant that they committed fraud, willful will statement, and availed illegal ITC. They said that fake or bogus invoice allegation is because their registration was cancelled.
Not only
But
this, because
how will he prove the negative?
Non-existence, my lord.
Correct, sir.
Non-existence.
Maybe it's non-existent.
If he is non-existent, my lord.
You need to put him on notice. He doesn't. He can say that, sir, he produced pro forma invoice.
Yes.
Through banking channel payment was made. I have filed my return.
Yes.
That return got auto-populated in the system. What more can I do? If then you will have to get that data, put it to him, reconcile. In fact, I passed a judgment just before the transfer here in 2021, as a result of which the mismatch issues in VAT. Here, circular was issued, statutory circular was issued, and that is how the process evolved. That it is not sufficient to say that that fellow is non-existent. bogus, fake, but you need to give the material to the dealer. And he will give corresponding material. Then his jurisdictional officer and the other selling dealer's jurisdictional officer should have a common interface. So the commissioner created that officer on the level of joint commissioner. Both officers will refer the data. He will compare the data. 90% of the mismatch cases were resolved. So he can't be proving the negative. No,
My lord, this point was not argued before the trial court. This was not. My lord will kindly see the judgment once.
We'll hear the matter. Sir, limitation, extended period, there is no allegation of fraud against or willful misstatement on the part of the appellant dealer. The allegation of fraud is because the supplier's registration was cancelled because of non-existent, and therefore the invoices are fake and bogus. Correct?
But then the but then the 155 burden of proof is there.
The person who is claiming that.
Yes, he is claiming the ITC.
Your Lordship, I have discharged my burden of proof.
So ITC is a concession subject to conditions. He has complied to the condition. You have not faulted him for any non-compliance on his part. He has been penalized by an action or something done by his supplier. That data he does not have.
No, probably that is not the only thing, my lord. Where
extended period it has to go.
Where the supplier himself is
the
not.
Intimation issued on the same allegation, reply given, intimation dropped, further action dropped. The cancellation of registration effected on 4/2/2023. You cannot resurrect.
My lord, that is only on 61 proceeding. That's scrut. My lord will kindly see 61 1 section.
You have heard so and so, so and so. In our view, the appeal requires to be heard as certain legal issues arise for consideration in the case. Firstly, as to whether the extended period of limitation could have been invoked in this case. To consider this, it is not required to adjudicate any disputed questions of fact, and the matter has to be examined based on the show cause notice, the allegations in the show cause notice, the reply of the appellant, and the finding recorded by the officer in the order of adjudication. Prima facie, it is seen that there is no allegation of fraud, no specified established allegation of fraud on the part of the appellant dealer, but the allegation is on account of the fact that the selling dealer has been stated to be a bogus party since their registration has been cancelled. To be noted that the registration, the cancellation of such registration is with retrospective effect. Full stop. Appellant's consistent case is that on the date when the supplies were effected, the registration of the supplier was valid. An invoice was raised, and the movements of goods have been established. Payments have been made through banking channel, and on account of retrospective cancellation of the registration of the supplier, the ITC availed by the appellant cannot be denied. The second aspect which also requires to be considered is whether on and after the intimation which was issued to the appellant on the same set of allegations by intimation dated 7/3/2023, for which reply was given by the appellant and the authority, namely the superintendent within bracket range 3, CGST and CX, Central Division, had accepted the reply and dropped the proceedings, accepted the reply against the notice issued under section 61 and dropped the proceedings by order dated 9/3/2023. The question would be as to whether with the same set of allegations, a show cause notice could have been issued. This aspect also can be adjudicated without going into disputed questions of fact. as the department has to establish from the available records that it can do so by while issuing the show cause notice dated 5/8/2024. While the appeal is being heard, the other issues will also be considered. Therefore, the appeal is admitted for hearing, and there will be an order of interim stay in interim stay restraining the respondents from initiating any coercive action against the appellant pursuant to the order of adjudication dated page number 80. Order of adjudication dated suppose I'll give it in the large
28/1/25. If I consider.
What is the order of adjudication date?
28/1/2025, Your Lordship.
28th of January 2025. The department shall give necessary instructions to the learned standing council. Let the appeal be listed on 25th September.
Your Lordship, kindly give the priority, Your Lordship. I wish to argue before it, Your Lordship.
You have argued, you got some order. Next.
Serial number 7.
Grateful, my lord.
7, I am for that.
No, I've got a meeting at 2, so let it remain in the list.
I'm begging your lordship pardon, my lord. Item 9, kindly let the matter be kept at top, my lord. My lord,
My lord, item 8, my lord, I'm praying 2 weeks time, my lord. Petitioner getting leave to affirm affidavit. Everything is ready, my lord. How to file affidavit? 2 weeks leave, my lord.
All right, item 8.
Item 8.
The request of the learned advocate for the applicant. 2 weeks time is granted to affirm the affidavit. Sir, this
item 9, my lord, I have given notice. All the parties are here, my lord. No, 9.
9.
Lord, item number 19, my Lord. Lord, item 19 was humbly praying if it to be taken up on Monday, my Lord.
Item 19.
1920.
1920, no time is sent. You give it September month.
Any day next week.
Item 9, who's appearing for the alleged contempt?
My lord, I am appearing for a local police station, my lord. And
contempt is against
Mr. Alok Ghosh is appearing for Kolkata Municipal Corporation, my lord. I have given notice, my lord.
He was here, no?
Yes, I have given notice.
Right. Let it remain in the list. We'll take it up tomorrow.
Your Lordship.
Tomorrow, my lord.
Kindly
I am
places
begging-
that matter, Your Lordship, on the second week of September. I wish to argue before Your Lordship.
Let us see.